Welcome back to the deep dive. Today, we're tackling something fundamental. It affects everyone, really, whether you've thought about it or not. What happens when someone passes away without a proper will? We're diving deep into the Intestate Succession Act 81 of 1987.
Right. This is the legal backstop, isn't it? The act that, well, pulled together and updated the rules for when there's no will guiding things. Our goal today is really to walk you through how it works, its core structure, but also, crucially, how this older piece of legislation has been getting some very important updates recently.
Yeah, 1987 sounds like a lifetime ago in legal terms. It was signed off September 30, 1987, kicked in March 88. But you're saying it's not just gathering dust.
Not at all. It's being actively shaped to fit modern South Africa. I mean, just look at the latest changes. They were literally incorporated this year, April 3rd, 2024. That came through the Judicial Matters Amendment Act. And there's even an administrative shift happening. Powers under the Act are moving over to the Minister of Justice and Constitutional Development, effective this coming October 11th, 2024. So yeah, dynamic is the word.
Okay, so before we get into the nitty-gritty of now, let's do a little legal archaeology. Before 1987, what was the situation? Must have been a bit of a mess if they needed this act.
Oh, it was more than a bit of a mess. It was, frankly, archaic and fragmented. The ISA 1987 didn't just tweak things, it swept away centuries of, well, quite frankly, confusing and sometimes conflicting laws. We're talking ancient Dutch rules from the 1580s, believe it or not, and the 1660s. Plus a whole load of South African succession acts from 1934, 62, 82. The point was to create one clear, modern framework.
Right, a clean slate. That makes sense. Okay, let's jump into the heart of it then, Section 1. This defines who actually counts as family, who gets to inherit, and this is where those modern adjustments really come into play, right?
Absolutely. This is where the law tries to catch up with, well, society and the Constitution. A big one was back in 2009. Section 1, subsection 2 made it crystal clear. Being born outside of marriage doesn't matter anymore for inheritance between blood relatives.
A major step for equality, definitely.
It really was. Removed a lot of historical unfairness baked into the old system.
And the latest change, the one from April 2024, feels just as significant, especially for couples who aren't married. Tell us about this new definition of spouse.
This is a big one, yes. Section 1 now has subsection 1A. It explicitly says the word spouse includes a partner in a permanent life partnership.
Okay.
And this is the key part, the partners have undertaken reciprocal duties of support.
Reciprocal duties of support. That sounds important. What does that actually involve? How do you prove that? It's not just living together, presumably.
No, it's definitely more than that. The courts look for evidence that mirrors the commitment of a marriage. Think shared finances, living together long-term, presenting yourselves as a couple, mutual financial support, essentially demonstrating that level of mutual commitment and dependency. It's about recognizing the reality of committed partnerships beyond just a marriage certificate.
That clarity is huge for many people. And what about children? How does the Act handle adoption, for instance?
Pretty clearly, actually. Section 1E states an adopted child is considered the descendant of their adoptive parents. Full stop. The link to the natural parents for inheritance is generally severed, unless, say, a natural parent is also an adoptive parent, which is a specific exception. And importantly, there's also a provision added in 2009, alongside the customary law reforms, that recognizes children accepted as one's own under customary law. Again, it's about reflecting diverse family structures.
Okay, so we've established who might be in line to inherit. Now let's get to the core mechanism, the hierarchy. Who gets what, according to Section 1.1?
Right, this is the roadmap. It works by elimination, depends entirely on who the deceased leaves behind.
Let's take the simplest cases first. Scenario A. Only a spouse survives, no descendants.
Easy one. The spouse inherits the entire intestate estate. Done.
Scenario B. Only descendants survive, no spouse.
Also straightforward. The descendants inherit everything. It gets divided among them per stirpus.
Per stirpus, meaning?
Meaning by family branch, essentially. If a child has predeceased but left their own children, the deceased grandchildren, that child's share goes to those grandchildren.
Got it. Okay, now for the one that often causes confusion, Scenario C. Survived by both a spouse and descendants. This is where it gets a bit more complex, doesn't it?
It does, because the law has to balance the interests of the spouse and the children. This is probably the most common scenario you'll encounter. The rule is designed to protect the spouse. The spouse inherits the greater of two possible amounts.
Greater of two amounts. Okay, what are they?
Amount 1 is a child's share of the estate. Amount 2 is a specific monetary amount fixed by the Minister of Justice, published in the Gazette. The spouse gets whichever of those two figures is higher.
And the descendants?
They get whatever is left over, the residue, if anything remains after the spouse takes their share.
Okay, so there's this fixed amount acting as a kind of floor for the spouse. What is that amount currently set at?
Right now, it's R250,000. That figure was set by notice back in 2014.
R250,000 since 2014. We'll come back to that maybe. But first, let's clarify the child share. How is that calculated? Let's use an example. Say, CFO passes away. His estate is worth R1.25 million. He leaves his wife and 3 children.
Okay, good example. To get the child share, Section 14F tells us, take the total value of the estate, R1,250,000 in this case, and divide it by the number of children who either survived CFO or who died before him but left their own descendants, plus 1 for the surviving spouse.
So 3 children plus the spouse makes 4 units for calculation purposes.
Exactly. So R1,250,000 divided by 4.
Which is R312,500.
Correct. That's the calculated child share. R312,500. Now, we compare that to the fixed amount, which is R250,000.
R312,500 is higher.
Right. So the spouse inherits the greater amount, which is R312,500.
And the residue for the kids.
The estate started at R1.25 million. The spouse gets R312,500, so that leaves R937,500. This residue is then divided equally among the 3 children.
So each child, where they line, gets R312,500 as well in this specific case.
Precisely. Now, if Sifa's estate had only been, say, R300,000.
Then the calculation changes things. A child's share would be R300,000 divided by 4, which is R75,000.
Right. And comparing that R75,000 to the fixed R250,000, the fixed amount is greater.
So in that smaller estate scenario, the spouse would take the full R250,000.
Yes, and the remaining R50,000 would then be split between the 3 children. It shows how that R250,000 acts as a safety net, particularly in smaller estates.
That makes the mechanism much clearer. Okay, so we've covered spouse and kids. What if there's no surviving spouse and no descendants? Where does the estate go then? We move up the family tree.
We do. We look upwards and outwards. This takes us to Section 1, D and E.
Scenario D. Parents are still alive.
If both parents survive, they inherit the estate in equal shares, half each. If only one parent survives, it gets a bit more detailed. That surviving parent gets half the estate. The other half goes to the descendants of the parent who passed away.
So the deceased's siblings, or nieces and nephews if a sibling also passed.
Exactly. The deceased's brothers and sisters, or their children, representing the deceased parent's line. And if that deceased parent had no descendants either, then the surviving parent takes the whole lot.
Okay, but what if there's no spouse, no descendants, and no parents left? Then we hit scenario E, right? This sounds like it could get complicated.
It can branch out, yes.
Yeah.
If we're in that situation, Section 11E kicks in. The estate is basically split down the middle. 1/2 for the maternal side, 1/2 for the paternal side. Each half then goes to the descendants of the deceased mother and the descendants of the deceased father, respectively. It tries to divide things equitably between the 2 family lines originating from the parents.
And if one side has no descendants at all,
Then the other side inherits the entire estate.
right. And finally, the last resort, scenario F, if absolutely none of those relatives exist.
Then, under Section 1F, the estate goes to the nearest blood relation or relations to the deceased measured by degree. They inherit in equal shares, regardless of which side of the family they are on.
Nearest in degree. How is that measured legally? Quickly, what's the rule there?
Section 14D explains it. In the direct line ancestor to descendant, it's just the number of generations. Easy. For collateral relatives like siblings, cousins, aunts, uncles, you count the generations up from the deceased to the nearest common ancestor, and then count the generations down from that ancestor to the relative in question. The total number of steps is the degree.
So it's a clear mathematical way to find the closest relatives when the immediate family isn't there.
Exactly. And remember that division we mentioned earlier, per sturbis. That applies throughout these scenarios where descendants inherit, ensuring representation down the family lines.
Okay, that covers the who gets what map. Now quickly, part 4, practical things that can change the outcome. What if someone doesn't want to inherit or isn't allowed to? Renunciation and disqualification.
Right. Someone might be disqualified, most obviously if they caused the deceased's death, or an heir might simply choose to renounce their inheritance, perhaps for tax reasons or just personal choice. The Act provides for this.
And there's a specific rule protecting the spouse again here, isn't there? Section 1(6).
There is, and it's quite powerful. If a descendant who isn't a minor or mentally ill is entitled to inherit alongside the surviving spouse, and that descendant renounces their share,
Yes.
that share automatically goes to the surviving spouse. It doesn't just pass down the descendant's line in that specific situation. It bolsters the spouse's position.
Interesting. And the general rule otherwise, if someone is disqualified or renounces and Section 1.6 doesn't apply.
Then, under Section 1.7, the benefit devolves as if that person had died immediately before the deceased and wasn't disqualified. So their share typically passes to their own descendants, if they have it.
Okay. One last crucial point before we wrap up this act. Isn't only for people with no will at all, right?
Right. Absolutely vital point. Section 1.4b defines intestate estate to include any part of an estate that doesn't pass according to a valid will. So if your will is old and only covers your house but not your shares, the shares fall under intestacy rules. Or if a clause in your will is invalid for some reason, this act governs how that specific asset is distributed. It covers partial intestacy too.
So it's relevant even if you think you have everything covered by will. Okay, summing up then, what's the big takeaway for listeners from our deep dive today?
I think the key insight is that the Intestate Succession Act provides a really clear, logical safety net. It's the state's default plan when you haven't made one. But crucially, it's not a dusty old relic. We've seen how it's been updated significantly to reflect modern ideas of family, equality, and partnership. It's trying to stay relevant.
It definitely provides structure. But speaking of things staying relevant, here's our final provocative thought for you, the listener. That fixed amount the spouse might inherit, the R$250,000, it was set in 2014. Think about inflation, the cost of living, property value changes over the past decade. How effective is that R$250,000 safety net today? And what does it mean if that figure isn't updated regularly by the minister via the Gazette? Something to chew on.
A very pointed question. It highlights the tension between fixed legal rules and a changing economic reality. Always more to explore.
Indeed. Thanks for joining us for this deep dive into intestate succession. We'll catch you next time on The Deep Dive.